that was after the PPI. We conducted a review of efforts of Gambia in anti-corruption prevention and so on its asset recovery efforts. And our findings also revealed that there was a joint commission soon after the former president was removed from power. And when he was removed from power, there was a commission of inquiry that looked into his assets and the way and manner he managed the economy of the country. And out of it, 38 individuals and entities were indicted by the commission. And some few assets have been seized, but the way and manner in which the assets were seized were not very clear. And there was a Supreme Court also decision to suspend the implementation of the decision of the commission. And since then, it has been a very big problem in the Gambia to follow asset recovery. And then we can see that in the judgment of the General Commission, there were a few sanctions which were given to those who were indicted. And this has been a very serious concern for us as a civil society organization. And so when we had the message from International Lawyers Project to inquire about how we can link up for a training on sanctions, we felt that that is a very good opportunity for us. And then we tried to link it up. It took us a very long time, and then this is where we have come to. And then when you see not so many Gambians involved, it's because of probably the lack of understanding and appreciation, because even when you look at the government, it's still dragging its feet on putting the right mechanisms in place to fight corruption in the Gambia. Only yesterday, the parliament was supposed to meet and decide on the anti-corruption bill. And what the Minister of Justice did is a clear indication that the country is not willing, it's not yet ready to fight corruption. Because they presented a document which is outdated as compared to what the deliberated on and then agree for the final reading. So you see the process of ratifying the anti-corruption bill into a law in the Gambia have once again been postponed. And these have been going on and off since 2013 up to now. In fact, it's 9 years now since Gambia put in the effort to get anti-corruption mechanisms. So I think if you are seeing this kind of low turnout from the public, it's because of lack of interest or stuff like this, or maybe, but I have a board member there, so I think whatever will come out, we'll be able to disseminate it. Thank you very much.
Thanks very much. Over to the Robson Gray team.
Come again, please.
Hi, very nice to meet everybody. I'm Sean Salinger. I'm a partner in the Anti-Corruption and International Risk Group practice group at Robson Gray. I am based in London, despite the American accent, and I'm joined here by my colleagues Tom, Samantha, Liv, Aaron, and Patrick. And my colleagues Eve and Dorota will be joining very shortly as well. Ryan, who is part of the team, unfortunately had to be traveling today. But we look forward to leading you through this training on anti-corruption and sanctions and asset recovery. And without further ado, I think it probably makes sense to get started. So I will turn it over to Tom and Patrick to walk through an overview of global human rights and anti-corruption focused sanctions in the first instance.
Sure. Thanks, Sean. So just first off, I think we should level set on what exactly sanctions are, because we see that word thrown around in the news often. Sanctions are penalties or restrictions that governments can put into place to influence or curb certain behaviors or achieve foreign policy goals. And then one of the key ways in which international law can be enforced. The primary sanction regimes you can see on there on the right-hand side are imposed by the United States through the Treasury Department, specifically an office called OFAC, or the Office of Foreign Assets Control. The United Kingdom, the European Union through its executive branch, the European Commission, and finally the United Nations. These sanctions can target anything from terrorism, be it state-sponsored or non-state actors, human rights abuses, drug trafficking, corruption, but above all, violations of international law. And a key thing to think about is the scope and structure that sanctions can take. They can be targeted against specific individuals. We often call those list-based sanctions. They can be comprehensive against an entire country. They can be targeted against specific sectors within a given country. And sort of a partner to sanctions is export control, which is limitations on the export of certain goods from certain countries or into certain countries. Next slide. So now that we have a general sense of what sanctions are, who do they apply to? Sanctions are one of the few laws that have relatively significant extraterritorial reach. U.S. sanctions, for example, apply to all U.S. citizens and permanent residents wherever they are in the world. They also apply to U.S. businesses and branches of U.S. businesses anywhere in the world. And then for certain U.S. sanction regimes, there's also application to non-U.S. subsidiaries of U.S. companies. U.S. sanctions can also apply, or do also apply to any activity in the United States, regardless of the citizenship of those involved. And critically, the U.S. can also have jurisdiction over transactions involving U.S. dollars or U.S. origin goods in certain circumstances, again, regardless of the citizenship of the individuals or entities involved in the transaction.
So from an EU and UK perspective, I think the general rule of thumb is that they are perhaps less wide-reaching in terms of their scope, but still, reasonably well wide-reaching nonetheless. So from the EU side, sanctions will apply to EU nationals wherever they're located, EU incorporated companies, including non-EU branches of those companies, but not non-EU subsidiaries. Any activity that takes place within EU territory will also be caught by EU sanctions. And then in terms of extraterritorial scope, from an EU perspective, there's the concept of circumvention. In essence, this prohibits anyone subject to EU sanctions from knowingly or intentionally participating in activities that have either the object or the effect of getting around EU sanctions. So for example, there would likely be a circumvention issue if an EU subsidiary of a company referred work that it couldn't do itself due to sanctions restrictions to a non-EU affiliate instead. That's the type of conduct that potentially would be caught by the circumvention provisions in EU sanctions. From a UK perspective, obviously, since Brexit, the UK has administered an independent sanctions regime. Broadly speaking, the concepts are similar here to the EU, notwithstanding some divergences since Brexit. UK sanctions will apply to UK nationals and legal entities, including their branches wherever the activities take place. They will apply to activities taking place within UK territory. And again, there's a very similar circumvention provision that seeks to prevent those subject to UK sanctions from getting around the restrictions in essence.
So that's who has to comply with these sanctions, but what do the sanctions actually do? And what do they restrict? The U.S. has, comprehensive sanctions against several countries, including Cuba, Iran, North Korea, Syria, and then certain parts of Russian-occupied regions of Ukraine. It also has targeted sanctions against individuals and entities on this list that OFAC puts out called the Specially Designated National List, or SDN list. Notably, any entity or individual on that list-based sanction on the SDN list, it also applies to any entity that's at least 50% owned by any specially designated national. and that, you can get into complicated calculations of how to figure out ownership there. The U.S. also has sectoral sanctions against, for example, certain financial services activity in Russia, and prohibitions on the provision of consulting or other professional services to Russia or to Russian persons. There's similar restrictions, sectoral sanctions in Belarus and Myanmar, Venezuela. And then the U.S. also imposes what are called secondary sanctions, which can target non-U.S. persons who are dealing with SDNs. So essentially, that means that non-U.S. persons that aren't on their own directly subject to U.S. jurisdiction can get totally shut out of the U.S. financial system if they are dealing with certain SDNs. That primarily applies to entities that are dealing with Iran and North Korea.
So I don't think we propose to go into this in too much detail, but just briefly to cover UK sanctions in overview. So since Brexit took effect in 2020, the UK now operates an autonomous sanctions regime. And as we'll come to, the UK's anti-corruption and human rights sanctions regimes were a couple of the relatively early examples of the UK breaking away from the EU's approach to sanctions. UK financial sanctions were enforced by OFSI, which is part of His Majesty's Treasury Department, and they cover broadly similar areas to the US sanctions that Patrick just outlined. So we have list-based sanctions. These are individuals and entities that are added to the list of sanctions persons. This means their assets are frozen, and those subject to UK jurisdiction are prohibited from engaging in virtually all dealings with them. And as we'll explain, both the UK's anti-corruption and human rights sanctions fall within this category. We also have sectoral sanctions. These are sanctions prohibiting certain dealings involving sectors of a particular country's economy. Commonly, these will target banking, oil and gas, sometimes tourism, those sorts of sectors. Unlike the US, the UK doesn't have comprehensive embargoes that prohibit virtually all dealings with a country or territory. But in the case of Russia, at least, we've seen sanctions that are sufficiently broad that they are beginning to prohibit a wide range of activities involving that country. Now, from an EU perspective, fundamentally, despite the fact that the UK now operates an independent sanctions regime, the EU and UK continue to share a lot of similarities. I won't cover them in detail here. Some divergences have begun to emerge in terms of the details, particularly in relation to Russia, which obviously since February last year has been a big focus of sanctions regimes. But in broad terms, the principles remain the same. Unlike the US, there aren't comprehensive territory-wide sanctions, but there are, in relation to Russia, now quite broad sanctions targeting a wide range of the Russian economy that in some respects could I suppose, be said to be approaching comprehensive sanctions. It's also worth noting that the EU is obviously a bloc of 27 member states, so there will be differences on a country-by-country basis in terms of both the scope of sanctions, but also the approach to enforcement.
So all of this brings us to the Magnitsky legislation. So Sergei Magnitsky was a tax advisor who was working for a London investment fund that was known for investing in companies in Russia and then exposing corruption. And Magnitsky was arrested, he was held without trial, and he ultimately died in a Russian prison in 2009. After which point his employer began lobbying hard for sanctions against the specific Russian officials who were allegedly responsible for his death. The US passed that narrow set of sanctions in 2012. But 4 years later, in 2016, the US expanded that law in what's known as the Global Magnitsky Human Rights Accountability Act. And what that did is it authorized OFAC to include in its list-based sanctions foreign government officials all over the world who are responsible for human rights violations. So it's specific list-based sanctions against human rights violators. Since that was passed in 2016, similar regimes have been adopted in Canada, the UK, the EU, and also some separate regimes within specific EU member states, and Australia. And currently there's similar legislation under consideration in New Zealand and Japan. But globally, taken collectively in the aggregate, these are generally known as the Magnitsky legislation. So very briefly, on the next slide, the U.S. global Magnitsky legislation, the targets of these list-based sanctions have to be non-U.S. persons, and they have either involved in serious human rights abuses, or they were government officials involved in corruption or misappropriation of state assets, or material supporters, leaders, owners of the same. So what happens when you're designated under the Global Magnitsky Act? Well, first, all of the person's property and property interests in the United States are frozen, as are all of their property and property interest held or in the control of any U.S. person, including banks. So that means all of the sanctioned person's assets in U.S. banks are blocked. They can't be moved. Same goes for real estate, equity interests, everything. U.S. persons are also prohibited from providing any funds, any goods, any services, pretty much anything to that sanctioned person or for their benefit. And so all of this is also subject to the 50% rule that I mentioned earlier. So any entities controlled or owned by the sanctioned person are subject to these same restrictions. And then finally, the sanctioned person himself is banned from entering the United States, or at least banned from being granted a visa. Some of the targets of Magnitsky sanctions in the U.S. so far have that are targeting certain human rights abuses include government entities like the security services in Xinjiang, China. There's been some individuals, including a billionaire named Dan Gertler for his corrupt mining deals in the Democratic Republic of Congo, the Saudi officials involved in the murder of Jamal Khashoggi. There's some politicians like the former Hong Kong chief executive Carrie Lam for her crackdown on democracy activists, and notably actually through sanctions and secondary sanctions and just general risk aversion from banks, Lam has publicly said that she pretty much lost all access to banking services and has had to deal solely in cash, including her paychecks. So since these came into effect. And then there's also some military forces like chief of staff of the Eritrean Defense Forces for violations of international law during the Tigray conflict. Penalties for violating U.S. global Magnitsky sanctions can be, on the criminal side, it can go up to 30 years in prison, monetary criminal penalties of up to several $1 million. And on the civil side, civil penalties can also reach well into the millions, although the average civil penalty by settlement is usually around $300,000 US.
So from the UK side, since Brexit, since the UK left the European Union, they've begun to diverge from the EU in terms of the scope and scale and details of their sanctions regimes. And one of the respects in which that is true is the adoption in April 2021 of an independent anti-corruption sanctions regime. This came into force back in 2021. We've seen a few waves of anti-corruption related designations since then. And the stated purpose of the regime, as you can see on the slide, is to ensure that the UK is not a safe haven for those involved in serious corruption, including those who profit from it. It's quite evident from the way the sanctions are formulated, as well as the list of targets to date and some of the UK government's language around this matter, that it has taken significant inspiration from the US Magnitsky sanctions with a heavy focus on UK and US cooperation. Indeed, as you'll see from the slide, US Secretary of State Blinken commended the adoption of these sanctions and specifically called out the focus on building a US and UK partnership. And certainly what we've seen to date is that a lot of the designations under the UK's anti-corruption, global anti-corruption sanctions regime have been in lockstep with the US, or at least that they target the same individuals as the US Magnitsky sanctions. In terms of the overview of the UK's global anti-corruption sanctions regime, the legislation sets out some criteria for designating individuals with these sanctions. In broad terms, there needs to be reasonable grounds to suspect that they are involved persons in serious corruption. The designation must also be appropriate, given the overarching purpose of the sanctions regime and the likely effect of the sanctions. The concept of persons involved in serious corruption isn't precisely defined, but there are a few categories provided that are indicative of the types of individuals that should be caught here. This includes anyone who is responsible for or who is engaged in serious corruption, anyone who facilitates or provides support for serious corruption, anyone who benefits financially or otherwise from serious corruption, anyone who conceals or disguises serious corruption or its proceeds, anyone who transfers or converts the proceeds of serious corruption, people responsible for the investigation or prosecution of serious corruption who intentionally or recklessly fail to fulfill that responsibility, any individual who uses threats, intimidation, or physical force to interfere in or otherwise interferes in any law enforcement or judicial process in connection with serious corruption, and anyone that fails to freeze the assets of or makes funds or economic resources available to an individual targeted by these sanctions. Interestingly, serious corruption itself isn't precisely defined, but guidance published indicates that this includes both bribery and misappropriation of property. Now, in terms of who's been targeted to date by the UK government with anti-corruption sanctions, so far, since 2021, there have been 35 individuals designated as part of the anti-corruption sanctions regime. While it's early days, a few patterns have emerged, and there's two primary categories of targeted individuals, being prominent business people on the one hand, and current or former government officials on the other. So in terms of business people, we've seen Vasil Boshov, who is Bulgaria's richest man who operates in the gambling industry. The UK government alleged that Boshov used extensive bribery to protect his business interests in Bulgaria and sanctioned him in a coordinated effort with the United States. The most recent media reports suggest that Boshov is currently hiding in Dubai. Another set of business people targeted are the Gupta family in South Africa, whom the Washington Post has described as the symbols of South African corruption. They're alleged to have used political connections and a network of bribes to influence cabinet positions and secure illicit state contracts worth billions of dollars. Again, they reportedly fled to Dubai and were arrested in 2022, pending possible extradition to South Africa. The third example we've included on this slide is Ilan Shor, a Moldovan Israeli national who's reportedly used bribery to secure his position as chair of a Moldovan bank, and then masterminded a fraudulent scheme that caused $1 billion to disappear from 3 leading Moldovan banks. According to the most recent report, Shor remains at large and has reportedly been involved in efforts by Russia to destabilize Moldova and bring it within the orbit of Russian influence. In terms of government officials, we've seen designation of Teodoro Obiang. He's the vice president of Equatorial Guinea. He's accused of widespread corruption and expropriation of Equatorial Guinea's wealth. He's noteworthy and notorious, one might say, for his lavish lifestyle, including luxury cars located across at least 3 continents, property worth tens of millions of dollars. And aside from the UK sanctions, which indeed caused Equatorial Guinea to close its embassy in London, Teodoro has also faced asset forfeiture actions on the grounds of fraud in both France and the United States, which led to the confiscation and sale of tens of millions of dollars in cars, houses, and other property. We've also seen a former governor of a province in Iraq become subject to sanctions under the global anti-corruption sanctions. He was accused of misappropriating public funds that were designed for reconstruction projects and improperly awarding public contracts and other state property. And then finally, the final example here is a high-ranking government official in Nicaragua who was accused of siphoning fees from public oil contracts for himself and other Nicaraguan leaders and using bribes and political connections to ensure his family's companies won government contracts. Again, this was one where the UK and US coordinated in designating this individual. Now, in terms of the consequences for an individual becoming designated under the UK's global anti-corruption sanctions regime, they become subject to an asset freeze. This prohibits anyone subject to UK jurisdiction from dealing with the funds or economic resources owned, held, or controlled by the designated person. All assets will be frozen, including bank accounts, and the individual won't be able to access them. There's a general prohibition against direct or indirect business dealings with any individual subject to an asset freeze, save for a few limited exemptions and licensing grounds. And then thirdly, there's a travel ban against those listed from entering the United Kingdom. And to the extent there is a permission to stay in the United Kingdom, that will be rescinded. Finally, in terms of penalties, on the criminal side, if a criminal violation is found, which is broadly speaking rare in the UK, an individual can be subject to up to 7 years imprisonment or a fine. More commonly, we see civil penalties. These can be up to a maximum of either £1 million per violation or 50% of the estimated value of the relevant funds or economic resources involved. The UK, in parallel with the global anti-corruption sanctions program, the UK has also implemented a human rights sanctions program. Indeed, this predated the global anti-corruption program and was implemented in June 2020. The stated aim of these sanctions is to deter and provide accountability for serious human rights violations committed on behalf of the state. These include violations of an individual's right to life, the right not to be subjected to torture or cruel, inhuman, or degrading treatment or punishment, and the right to be free from slavery, not to be held in servitude, or required to perform forced or compulsory labor. To provide an overview of the UK's human rights sanctions regime, the UK government has a very broad remit to consider all relevant considerations when making designations under this regime. This may include, but this is not an exhaustive list, the UK's human rights priorities, such as media freedom, modern slavery, sexual violence, freedom of religion, and torture prevention, the nature of the victims and the threat of potential reprisals as a result of the UK government's actions, the seriousness of the relevant misconduct, the status and connection of those involved, and the international profile of the relevant issues. And the UK guidance here specifically calls out the potential for collective action with other governments. In terms of who we've seen targeted to date, these include government entities, such as 2 North Korean government organizations that have been responsible for running a network of prison camps in the country, have been implicated in forced labor, enslavement, torture, and murder against prisoners. In terms of individuals, similar to the US position, we've seen 20 Saudi nationals that were involved in the abduction and murder of Jamal Khashoggi at the Saudi embassy in Istanbul, as well as 25 Russian nationals involved in the mistreatment and death of the Russian lawyer Sergei Magnitsky, whom Patrick has already covered. The final category of targets we've seen under the UK human rights sanctions is military figures. In particular here, we'd call out two high-ranking Myanmar military generals who've been implicated in violence committed against the country's Rohingya population, including sexual violence, violations against children, torture, and village burnings. Now, the consequences and penalties are broadly the same as those for the anti-corruption sanctions regime, and indeed financial sanctions in the UK more broadly. Again, you're looking at an asset freeze, a prohibition against UK persons having any dealings with these individuals, and a travel ban and rescission of any permissions to stay in the UK. Likewise, penalties here are the same. On the criminal side, up to 7 years imprisonment or a fine. And from the civil side, penalties up to the greater of £1 million per violation, or 50% of the economic resources that are involved in the relevant transaction. So that's the end of the introduction to global human rights and anti-corruption sanctions from a US and UK perspective. I'm not sure if there's any questions at this stage before we move on to asset forfeiture and recovery.
Just before we move on, not a question obviously from my side, but maybe just one point to flag for the audience. You know, obviously we've spent most of the time focusing on the US, UK, and EU, and mentioned a couple of other countries in terms of the sanctions regimes that they have implemented, often following, you know, very much a similar path, particularly in the last year with respect to Russia. But I think it's just important to emphasize that the concepts here in terms of the way that sanctions can act, can operate, particularly in the human rights and anti-corruption means are you know, available for any sovereign nation, you know, anywhere in the world to develop and implement based on their own priorities and foreign policy goals and so on. So I think it's just important to emphasize that while this overview was, you know, focused on a few jurisdictions, the concept and the principles can be extended really from a global perspective.
Okay, I'll hand over to Olivia and Aaron then, who I think are handling the next section.
Yep, thanks all. So my colleague Liv and I will be taking over the next few slides to talk about international best practices in asset forfeiture and recovery. So as I'm sure many of you are familiar with these terms, but just to give some basic background to start, we wanted to quickly review the definitions of asset forfeiture and recovery. So what is asset forfeiture? It's also known as confiscation, and asset forfeiture involves the permanent deprivation of assets by order of a court or other competent authority, such as an agency. Confiscation actions can be brought either domestically in the victim country or in the country where the proceeds of the criminal activity or corruption are located, which is the recipient country. It's important to note that a confiscation or asset forfeiture order, if a confiscation or asset forfeiture order is made in a recipient country, those assets are not directly repatriated to the victim country. And the same is true if the order is made domestically. This doesn't automatically mean that the assets are directly returned to the victim. So this is only the first step of many, which leads us to the second definition of asset recovery. Asset recovery is the process by which the proceeds of crimes, including corruption, are returned or repatriated to the country from which they were taken or to their rightful owners. In the next slide, we just wanted to take a minute to discuss the relationship between anti-corruption and human rights in asset forfeiture. Corruption and the stealing of assets, as you might expect, can have a negative impact and can often violate the human rights of individuals and groups. And for that reason, corruption can be understood more broadly as a human rights issue. You can find human rights considerations in almost every stage of the asset forfeiture and recovery process itself. And these policy considerations are not only to protect the human rights of those who are victims of the corruption, but also the rights of those who are subject to the asset recovery. In other words, it's important to avoid depriving a person of their assets without reason or due process. Recovery of assets in the context of human rights abuses is slightly different than in the context of corruption. Often it's a case of compensation rather than a restitution of assets, and the focus is more often on redistributing the assets to the public rather than recovering them for a single victim.
So moving on here, as discussed earlier by Tom and Patrick, the various jurisdictions have sanctions regimes in place, but it's important to note that asset recovery and forfeiture regimes are often separate pieces of legislation. And therefore, whilst they're often conflated, they operate separately. So for example, sanctions contain provisions for asset freezing or the prohibition of dealing, but generally don't include provisions for recovery. This is actually subject to discussion in itself. So whether sanctions and recovery legislation should actually be derived from the same legislation. For example, in the UK, there's discussion about whether the operation of the two regimes separately actually works to exclude each other. So for example, whether when an individual is designated under sanctions, this actually prevents follow-on use of asset forfeiture and recovery legislation to enact consequences on that individual. And similarly, in relation to this, there's been recent discussion surrounding the Russian-Ukraine war surrounding the use of sanctioned assets under asset recovery and forfeiture legislation, which suggests a conflation of these two regimes. So, for example, in the UK, in the EU, there's been discussion of using assets sanctioned under the Russian sanctions to provide damages or reparations to Ukraine. So, for example, in the short term, this could be setting up a structure to manage frozen public funds, which may include investing them, and then using the proceeds from such investments in favor of Ukraine, for example, providing short-term aid, short-term relief, and in the long term, when sanctions are lifted, considering the possibility of offsetting confiscated public assets against possible damages or reparations that may be owed to Ukraine under any peace agreement. And similarly, steps have been taken in the US that reflect this. For example, the White House Graham Amendment there allows the US Attorney General to transfer the proceeds from any sale of forfeited assets under Russian sanctions to provide foreign assistance to Ukraine. So moving on to the next slide. So here we're just considering some of the legislation that is used in these jurisdictions for asset forfeiture and recovery regimes. So, for example, the UK here has 3 pieces of legislation, all from different periods of time, that are used to kind of fill the gaps that prior pieces of legislation may have missed. In the EU, there's various pieces of legislation, such as the directives, the framework decision there, and this is currently being supplemented by a recent proposal for the directive on asset recovery and confiscation. And the UN there has obviously the Convention Against Corruption, which is accompanied by the technical and legislative guide, which are legally binding, that is supplemented by various guiding principles and recommendations, such as the Office of the High Commissioner for Human Rights recommended principles on human rights and asset recovery, as well as the Office for Drugs and Crime for the UN, which has non-binding principles relating to the management of frozen assets.
And just going back to the last slide to talk about the US. So in the US, there's no unified or comprehensive forfeiture legislation. Instead, what constitutes US forfeiture law today is more of a collection of federal and state laws, as well as some procedural rules. Focusing on the federal side, Congress has enacted several laws which contain provisions governing the authority, scope, limitations, and procedures of asset forfeiture. Administrative and civil forfeitures are governed mostly by one section of the United States Code, whereas criminal forfeiture is governed principally by a separate section of the code and the federal rules of criminal procedure. And finally, the US asset forfeiture program is enforced within a section of the Department of Justice, which is called the Asset Forfeiture and Money Laundering Section, or the AFMLS. And the AFMLS has launched an asset recovery initiative, which allows the Department of Justice to recover assets on behalf of countries victimized by high-level corruption and restore those assets to their rightful owners. In the next few slides, we're going to go over 5 broad stages in which you can consider asset forfeiture and recovery. The first is to trace and identify the illegally acquired assets. The second is to freeze those assets. The third is to manage those frozen assets to preserve their value. The fourth is to recover the illegally acquired assets. And finally, the return of the confiscated assets, including reusing them for public or social purposes.
So looking here at stage 1, some of the best practices across the jurisdictions here. So in the EU, we have member states being required to set up asset recovery offices, which are used to facilitate tracing, and the EU actually encourages information sharing between the offices across member states. So for example, this includes exchanging best practices, discussing any strategic and operational issues that the offices are facing in tracing and identifying acquired assets. And this also includes a light peer review process where the offices can discuss aspects of each of the national asset recovery systems and potentially where they can be improved. Looking at the UN, so the guidance from the UN encourages both domestic and international cooperation to assist with tracing and identifying illegally acquired assets. So for example, it encourages technical assistance and information sharing between both the requesting and the requested state, especially where a state that is requesting assistance lacks potentially either the evidence or the expertise needed to meet the formal requirements of a mutual legal assistance request, which is the formal request under the UN for assistance across states. And here they recommend the networks that have already been established being used as a forum for training and improvement of processes. So, for example, the UN highlights the Global Operation Network of Anti-Corruption Law Enforcement Authorities as a useful network in this regard. The Stolen Asset Recovery Initiative, which is a joint initiative between the UN and the World Bank, also recommends proactive contact with other jurisdictions. So this can include informal outreach prior to a mutual legal assistance request, for example, in order to assist with understanding a foreign legal system and the potential challenges that could arise using that system, as well as information sharing, developing possible leads that may assist with a strategy for recovering assets. And moving on, they also recommend using a range of investigative processes in order to collect as broad a base of information as possible. And this can be undertaken through using both domestic and international coordination. So this can involve coordinating across various government departments or intelligence units as appropriate. And this can take the form of either an ad hoc task force surrounding a particular case or a more permanent committee where that has been established in a country. And linked to this, where there are legislative gaps or issues that prevent such information sharing or coordination between member states or departments across governments, for example, these can either be addressed through updating the legislative framework or through ad hoc memoranda of understanding that can assist on a case-by-case basis.
Similarly, investigators in the US trace assets mainly by conducting financial investigations, during which they determine a subject's assets, examine the revenue generated by the criminal activity, and try to follow its trail. In the US, there are 3 categories of relevant financial information that are examined. The first is open sourced, the second is restricted, and the third is protected. Which category a piece of information belongs to dictates how easy it is to acquire. So open source information would be the most easily acquired and protected information the most difficult. So best practice here would be to have as much information be open source as possible in order to promote transparency and assist such investigators in identifying those illegally acquired assets.
Moving on here to stage 2, so freezing identified assets. Best practices here focus on immediacy and using a number of tools and applications in order to prevent asset flight or the removal of assets so they can no longer be recovered or frozen. So in the EU, the current proposal directive seeks to introduce urgent freezing powers, which helps to assist this and helps to prevent the asset flight prior to the implementation of any seizure or confiscation mechanisms that might be undergoing. In the UK, similarly, you can apply for a freezing order alongside other mechanisms such as an unexplained wealth order. So the simultaneous application of several mechanisms here help to ensure prompt action that prevents asset flight and ensures that these assets can be frozen. And again, in the UN, several mechanisms are recognized as being useful in preventing the disappearance of assets. So here we list a few: sequestering, injunctions, restriction orders, and monitoring of enterprises or accounts. And these all help with temporary restrictions of disposition and use of assets. The UN also recognizes the need for competent authorities in states that have a request from a state seeking the freezing of assets to be able to act on a foreign freezing or seizure order, or simply on the basis of a request from foreign authorities to do so, provided that there is a reasonable basis. And in connection with this, the UN recognizes that sometimes best practices can include a more flexible, informal approach where rapid procedure can't rely on lengthy orders, for example. So the UN here highlights the cases of the Canadian and Swiss regimes, which allow Canadian and Swiss governments to freeze assets in a proactive manner where there is political upheaval or the failure of state institutions in the state of origin to assist with freezing assets before disappearance.
In the US, mainly after a conviction of a crime, all assets that are linked to such crime are forfeited to the United States. But before a conviction, the government can also apply for a restraining order to freeze tainted assets in order to preserve those assets for forfeiture immediately upon conviction. The bar to receive that restraining order is not very high. The government only needs to show probable cause that the suspect or suspects are guilty of the crime and that the assets are in some way linked to the crime. As to untainted assets or assets that are not linked directly to a crime, the US courts are divided regarding whether the government can freeze those assets at all. However, the US Supreme Court has held that untainted assets that are needed to hire an attorney must be exempt from pretrial restraint so that the defendant can hire counsel of his or her choice.
Now looking at the third stage, so the management of frozen assets to preserve their value. So the UN's Convention Against Corruption requires states to adopt legislation or other measures to regulate the administration of frozen property. However, it's recognized that this is an area in which states struggle, and therefore the UN encourages states to share their experiences so as to identify best practice and to improve this area. But in the meantime, the United Nations Office on Drugs and Crime are currently revising their non-binding guidelines on the management of frozen, seized and confiscated assets. And some of the current guidelines offered in the current guidance include suggesting states to consider pre-confiscation sale of an asset where an asset may be rapidly depleting in value in order to preserve this value, where the proceeds are then frozen. And also they suggest that states decide on the institutional structure of asset management based on factors specific to that country. So for example, how often a country is getting a request to freeze assets, and the current public institutions to determine whether there are any institutions that can be used already in this function, or whether a new public institution would need to be created, for example.
Similarly, the processes for managing frozen assets to preserve value are pretty light in the US. Similar to some of the UN considerations, the Department of Justice in the US favors pre-forfeiture sale of property as a means of preserving asset value and mitigating the expenses of preserving that value on the government's end.
Looking now at stage 4, so the recovery of illegally acquired assets relates to the actual confiscation of the assets. And the best practices here focus on using a variety of mechanisms. So for example, the EU recognizes both conviction and non-conviction based confiscation. So this focuses on civil recovery that isn't necessarily linked to the conviction of a crime. And this is similarly recognized in the UK. So the UK has been historically criticized for its reliance on the need for a foreign conviction in order to implement a seizure and recovery order. However, the UK is attempting to address this, for example, through the introduction of the unexplained wealth orders. So an unexplained wealth order in itself is not a power to recover assets. However, they can be used in civil procedures to do so. So for example, an unexplained wealth order requires the respondent to prove the legitimate source of their wealth. And if they're unable to do so, this can be used later in civil recovery, and failure to respond to a request can actually be used to allow recovery under the Proceeds of Crime Act. Additionally, so in addition to freezing orders discussed earlier, law enforcement agencies can use forfeiture orders, which allow the forfeiture of assets within an account unless an objection is made.
There are a few different ways to recover illegally acquired assets in the US, but the two most common of those ways is through a civil or administrative procedure against the asset itself, or a conviction in a criminal trial. Prosecutors who commence a forfeiture case in the US must provide proper evidentiary and legal bases that support the policy objectives behind the forfeiture. So for example, they have to show what the violation is, if there's a relevant forfeiture provision, what ties the asset to the violation, how the asset would be seized, the value of the asset, its current location, and who owns or controls the asset.
And now on to the last stage, so stage 5, which is the return of confiscated assets, either to the country of origin or to individuals, and the reuse of those assets. So looking at the UK here, the UK has no specific domestic legislation that enables confiscated assets to be returned. However, and this has historically been an area of criticism of the UK regime, as well as the generally slow response to requests for mutual legal assistance. However, the UK does consider itself bound by Article 57 of the Convention Against Corruption, which requires the return of confiscated proceeds. And in order to improve its response here, the UK has recently, in 2022, introduced a framework which sets out the process for return, and various other aspects, such as the role of stakeholders who should be involved in the process and engaged in the mechanisms for return. Turning to the UN, so the UN recognizes that the process for return may actually differ based on the crime. So for example, the proceeds of embezzlement should be directly returned, whereas in other offences, there may be considerations that should be taken into account, such as who needs return as a victim, for example, or other aspects. The UN also focuses on ensuring that return funds are traced and monitored, and this can be both by the country of origin as well as the country that is returning the assets. And an important factor here is that these assets are kept separate from the central budget, potentially in a dedicated fund established by a third party outside of the government. The UN recognizes that the mode of return should be subject to an agreement. So there should be some sort of framework in place that is monitoring the return. So for example, the trilateral agreement between the US, Jersey, and Nigeria is seen as an example of good practice regarding accountability. And in this case, the Nigerian Sovereign Investment Authority is tasked with administering the funds, and this is then monitored by an independent civil society organization. Return of assets should also be transparent, and information should be made easily accessible to the public and civil society, including the agreements which are governing the mode of return. And this highlights the role of civil society in the return of assets, not only for accountability and transparency, but also to assist with identifying victims and identifying who the funds should be repatriated to, which also leads to the role of civil society in the memorandums of understanding and the return of assets more generally. So, for example, in the agreement between the United States, Switzerland, and Kazakhstan, the BOTA Foundation, which was an independent non-governmental organization, was established under the memorandum to assist with the asset return process and to assist with transparency and accountability. Additionally, the UN suggests that memorandums actually include the purpose for which the assets should be returned. So this can either be more general or quite specific. So, for example, the agreement between the US, Jersey and Nigeria in 2020 stated that the repatriated funds would be returned to Nigeria to help finance 3 specific infrastructure projects, whilst other agreements, such as the agreement between the US, Switzerland and Kazakhstan, more generally was for the promotion of children's rights. And under this kind of more general heading, that the memorandums should include the purpose for which the return assets should be used. This can also include furthering anti-corruption initiatives, although currently this isn't common practice, but could be a consideration moving forward.
The US is currently undertaking a distributed ledger programming project, which is aimed at increasing transparency and accountability with respect to the disposal of assets returned by the United States to a recipient country. As discussed in the first step of asset forfeiture, an open source system here would provide information about how funds are dispersed to the recipient country. The US also has an Operation Goodwill program in which forfeited property of marginal value can be transferred to state or local governments in support of community-based public health and safety programs. The most important issue confronting the US right now is finding the right balance between 2 equally important and competing interests. And the first is the need to immediately apply the proceeds of successful forfeiture efforts to the benefit of victims, whereas the second is the need to ensure that all such successful forfeiture efforts will not be wasted, and taking care that repatriated assets will not make their way once again into the pipeline of criminal activity, including corruption. Finally, we just wanted to go over some of the main takeaways that we discussed. The first is cooperation. Mainly, we wanted to, or the best practice is to introduce international cooperation mechanisms as appropriate. For example, to consider establishing an asset forfeiture fund for other countries or authorizing asset sharing with other countries through some of the memorandums of understanding that were discussed. On a more domestic level as well, cooperation between different departments, between the government and NGOs or other organizations is really critical for success in cases of asset forfeiture and recovery.
Implementation, so fast and effective implementation of mechanisms is crucial to ensuring that assets are traced and identified quickly and frozen quickly before they disappear. And in this regard, linking back to the role of sanctions, sanctions authorities often work from tips, and so the fast implementation can be assisted through providing information to sanctions authorities who may be able to designate individuals, for example, under sanctions. Variety is also a useful takeaway. So each of the jurisdictions considered use a variety of mechanisms to assist with the asset forfeiture and recovery process. So, for example, this can be both conviction and non-conviction based recovery, and a variety of other processes for recovering and freezing assets. Fourthly, education and guidance. So more generally, providing guidance surrounding legislation helps with the effective implementation of a regime that operates effectively and properly. So, for example, the technical and legislative guide around the UN's Convention Against Corruption are particularly helpful with implementing the convention, and that can be a consideration around the legislation implemented, or other non-binding guiding principles, for example. And additionally, education between states and networks can provide a useful form of training for states requesting assistance with asset recovery. So for example, using states that have strong asset recovery regimes is a great way to learn best practices that can be implemented into domestic regimes.
The fifth takeaway, prevention, asset forfeiture and recovery only come into play after fraud or corruption or human rights abuse has taken place. And this should really be a last resort. It's equally as important to take preventative measures, such as implementing additional provisional measures for early and proactive asset protection before the need arises to forfeit the assets from the person who was convicted of the crime. And then finally, disclosure. It's really, really important to increase interdepartmental, interministerial information sharing on both the domestic level as well as an international level for ease of access to information, to be able to not only trace and identify the assets, but also for understanding where the assets are going to go after they've been forfeited and recovered. And disclosing these practices to the public and being transparent about where these forfeited assets are and the tools that the public can use to understand, the importance of asset recovery to be able to trust the process is really important.
Hi, everyone. So now moving on to the case study. The case study relates to the former President Jammeh. And there's basically two places where assets can be forfeited, as was mentioned by Liv. The first one is in the victim country, which is the Gambia. And the second one is in the recipient country, which is, in this case, the United States. So I will briefly speak about the Gambia, and Samantha will take the US part. So by way of brief background, President Jammeh was the leader of Gambia until 2017. He lost power and currently remains in exile. His rule was characterized by human rights abuses, significant fraud, and corruption, and it is estimated that he and his family members and associates looted up to $1 million. In July 2017, a commission was set up to inquire into the activities of Jammeh. The inquiry of the commission was civil in nature and focused on investigating the loss of assets, but did not investigate any allegations of torturous or criminal wrongdoing. And that was actually done by a different commission to this one. Okay, next slide, please. So the commission's powers were very wide and included investigative powers, making recommendations regarding the recovery and restoration of any assets, and the power to make interim orders to preserve the assets which were misappropriated by Jammeh and his associates and family members. The commission made its report available to President Barrow in March 2019, and a government white paper based on the report was published in September 2019. Among others, it was found that Jammeh and his associates and family members did misappropriate very large sums of money. So this slide shows in detail how the money was split up. But I think we can probably move on to the next one. Okay, so basically the money was misappropriated in very different ways. One was that Jammeh and his family members had excessive control over the central bank of the Gambia, and so they were able to withdraw funds for private purposes from public accounts. They operated commercial accounts with the Central Bank of Gambia and acted as the sole signatories in relation to accounts holding public funds. They also diverted funds from accounts set up for specific commercial purposes in the public's interest, and also from accounts set up for charitable purposes. A large amount of foreign aid was received from Taiwan, and that was misappropriated and moved into global accounts held for the benefit of Jammeh. And also properties were seized without paying financial consideration, and this included public lands such as forests or lakes. So the Gambian government accepted all of the recommendations and also accepted a recommendation that criminal proceedings be instituted against Jammeh for theft, economic crimes, and corruption. And similar recommendations were also accepted by the Gambian government in relation to Jammeh's close associates. Okay, next slide, please. So I think, we discussed about kind of making recommendations, but the important thing is, were these assets forfeitures successful? And here it seems like some problems have been run into, because in June 2020, the Gambian Court of Appeal held that the Commission recommendations cannot legally render a binding decision which can be executed or enforced as if it were a judgment of the court. The ruling was in connection with a case brought by a company called M.A. Karafi and Sons. And so what happened was that the commission had recommended that this company pay a restitution of 2 million and interest. And the company applied for a stay of execution. And in fact, the court held that a commission is just an investigative and fact-finding body. So the recommendations of a commission cannot be enforced in any court. The court also examined whether a white paper could be held to be enforceable, and it was also the case that a white paper could not be held enforceable and was not considered a judgment. The court flagged that if the intention was for the commission to have the power to impose criminal penalties or civil remedies, that should be done through the constitution. And in fact, in Ghana, where a similar scenario happened, the constitution was amended so that proceedings such as these could be enforced. So unfortunately, as of now, it seems like there's little information available about the current state of the enforcement proceedings and the asset forfeiture in the Gambia, but Sam will talk about the US enforcement and asset forfeiture actions, which were more successful.
Okay, so as Dorota mentioned, Jammeh had made acquisitions abroad, including the U.S. In 2020, there was a civil action that was commenced to seize Jammeh's Maryland property, which was purchased with approximately $3.5 million in alleged corruption proceeds through a trust set up by his wife. And the U.S. had alleged that Jammeh had corruptly obtained millions of dollars through the misappropriation of stolen public funds by soliciting bribes from businesses seeking to obtain a monopoly from the Gambian economy. And in May 22, the U.S. Department was able to secure the forfeiture of the property. And although there hasn't been any updates as to what happened with the property, the U.S. government does intend to sell the property and has recommended to the Attorney General that the net proceeds from the sale of the property be used to benefit those who were harmed by Jammeh's acts of corruption and abuse of office. So Jammeh had also had some US and UK sanctions. In December 2017, he was sanctioned by the US Treasury under the Global Magnitsky Human Rights Accountability Act. This executive order 13818 by President Trump ordered that all properties and interests in the US or hereafter that come in the US are blocked, and they may not be transferred, paid, or exported. And they also prohibited any donations for the benefit of the property that is blocked. And then in December 2020, he was also sanctioned by the UK HM Treasury. And here there was freezing of funds and economic resources held by Jammeh, as well as his wife and one of their business associates. And then there was also a travel ban that was imposed on them. And that's it.
Thank you, Sam and team. I think we have a few minutes in case there are any questions.